Hello, everyone. This is Tom Fox back again with Matt Kelly for another episode of the award winning Compliance Into the Weeds. Today, it is the first episode of 2025. So, Happy New Year and hello to all of our listeners and to you as well, Matt.
Thank you very much, Tom, and Happy New Year to you too.
Matt, your background would suggest you're not in the world headquarters of Radical Compliance. Where do we find you today?
Oh, I am in Charlotte, North Carolina today. Apparently, I have dodged whatever wild weather is causing trouble in the middle of the country. But I'm here in Charlotte, North Carolina, first time ever, to hang out with some NavX people who are having a meeting down here just to talk shop about a couple of things. But it is a great time.
For those of you listening to this podcast in the audio format, I will tell you Matt is dressed incredibly professionally, nicely trimmed hair, sporting a sport coat, looking very sharp and dapper.
Anything for a good client meeting. Yeah, anytime it's just you and me, Tom, I'm in t-shirt and sweats back home.
Matt, you, as usual, tend to post early in the new year, looking forward, not retrospectively, and you have done so again. So I thought we might explore at least some of the top five stories, perhaps not the top five stories you're thinking about early January 2025. Let's just go through them.
Sure thing. Yeah, this is something I do every year where I try and think of compliance related events that are likely to happen in the coming year that are somehow telling or significant for compliance officers. So, not necessarily even the biggest news that might happen, but things that might slip under your radar. But nonetheless, if they do happen, would speak volumes about the changing nature of what compliance officers have to do or landmark sort of twists and turns in what we worry about. I picked five basically because that rhymes with 2025, but there are a lot out there. It was hard to do, but I did finally narrow it down to the five. I don't know where you'd want to start.
I want to start with Gautam Adani because that has had as many twists and turns as any story that broke 3 weeks ago.
Yes, this is the first thing I'm most curious about is whether or not the corruption prosecution of Gautam Adani will continue. Now, for those who might remember, Mr. Adani, he is one of the wealthiest men in India, apparently the second wealthiest man. He is worth $84 billion. And he is also a close friend of the Indian Prime Minister Narendra Modi. And he is under indictment under U.S. law. The Justice Department and the Securities and Exchange Commission filed criminal and civil corruption charges against him and his nephew, who are owners of, senior executives of the Adani Group in India. They filed corruption charges, but I want to be clear that they did not file Foreign Corrupt Practices Act charges against those two. This is a complex case here, but basically, this is clearly an FCPA-like sort of a scheme where Mr. Adani and his business associates and the company were accused of paying bribes to government officials to win solar energy contracts with the Indian government. For whatever reason, neither the Adani Group nor Mr. Adani or his nephew Sagar Adani were personally charged with FCPA violations, but about a half a dozen other business associates were charged with FCPA violations. Adani was charged with wire fraud and securities fraud, but not FCPA fraud. I'm not quite sure where we draw that distinction or why these charges fell the way that they did. But Tom, this is just a politically explosive case. It is a big deal in the United States, but it is a hugely big deal in India, where a lot of people who are critics of the prime minister say that this is more proof of corruption in his government and cozy relationships he has with the oligarchs over there. However, I am more concerned about whether this case will continue in the Trump administration. If there were ever an example of a rich and powerful connected person who theoretically could buy his way out of a corruption case, Adani is that man. I am not saying that's going to happen or that he might do that, but he personally says that these charges are baseless and that they will fight them. But if, for example, someone, Mr. Adani or anybody else, wanted to call up their prime minister, who is their BFF, and say, could you please call new President Trump and get him to drop these charges? Or maybe Adani just donates a bunch of money to Donald Trump directly. And one of his charities, quote unquote, or some other political action committee that's controlled by Trump. And then Trump has his Justice Department drop the case against Adani. Could those things happen? Absolutely. Yes, they could. Adani certainly has the wealth and connections to make that happen. I am curious to see whether the Justice Department under the Donald Trump would actually go along with that, which I think would send a terrible message to the anti-corruption community and to the corporate compliance community. Or at the least, if there is some bizarre explanation or hackneyed way to justify that maybe this case shouldn't move forward, okay, but in that case, the Justice Department really should explain itself very fulsomely about why we are now going to change course. The indictment against Mr. Adani looks quite clear and compelling to me. So if new lawyers at the Justice Department don't want to proceed with this, why not? Because if they don't explain why not, it will look like Donald Trump is doing favors for politically connected cronies. And how are we supposed to take FCPA prosecutions or corporate corruption prosecutions seriously if rich guys can buy their way out of them? So that's item number one on my list.
Play a couple of strands of that out a little further, Matt. You mentioned specifically a donation to a charity. I was wondering, though, what about a business investment? What if an Adani company decided Truth Social was a hugely possibly upside event, and there is a business to business investment, purchase, or other vendor related transaction that the public might never know about? And it would seem to me that would be a very easy way to get someone's attention who might own that business. The second is there is, in my mind, a question about extradition to the United States. Now, that question will be posed to the Indian courts and whether Adani has influence in the Indian courts, whether India will extradite the number two richest man in India, or whether legally he is extraditable are, in my mind, all open questions. And I could see one response from the DOJ is we don't think he's extraditable. We don't think he committed a crime in the United States. We're going to drop the indictment. Two might be we're going to really try very hard, just like the Patriots did with Jared Mayo, to bring him to the United States. But we have to let the Indian justice system take its course. So it seems to me there's some other strands that would have to play out, but I'm really concerned about a potential investment in a private to private company that the public would know nothing about. Yet that could be a way that Trump told the DOJ, no, don't move forward.
It is interesting, specifically to the business investments. That is an equally valid way for somebody to exert business influence with Donald Trump. Of course, in a perfect world, a government official would be serving a higher purpose and would not even have these investments and would be putting all of his business ventures into a blind trust. Anybody who believes that Donald Trump is actually going to do that, I have a bridge I could sell you in Brooklyn. And Tom, to your point, this is not actually hypothetical. We've already seen other people on enforcement radar doing this. There is that cryptocurrency investor who lives overseas, Justin Sun, I believe his name is. He's the one who spent the $6 million to buy that banana artwork of the banana duck taped on the wall, and then he promptly ate it. What? I mean, that's a whole separate thing we can discuss some other day. But Justin Sun has now invested millions in a cryptocurrency venture owned and operated by the Trump family. And he's under investigation by the Securities and Exchange Commission. How is this supposed to work? And let's say that for whatever reason, the Adani prosecution does not move forward. I don't necessarily think that the extradition issue is all of that valid. There have been plenty of cases before where we have indicted people and held them accountable who are never going to get over here, who are Chinese authorities or something like that. If the Indian Justice Department moves at its own pace, granted, then we'll get him extradited right after the sun goes red giant in 5 billion years. But nonetheless, I don't think that's going to be the hurdle. I think the hurdle is going to be, will Donald Trump actually get involved in this case? And will he see this as maybe a bargaining chip for some other geopolitical issue that he might have? That is something that we saw discussed in the first Trump administration, where he weighed in with the indictment and the settlement against ZTE, and then later on against Huawei, where we had held one of their senior executives. This can get very messy, and all of it suddenly sort of eclipses the prosecution of corporate misconduct. But ultimately, I'm more worried that Adani is going to ask for a favor because he's a rich guy and he can get favors. And then if he does, how are we ever supposed to take the Justice Department seriously again? How are we supposed to listen to the Deputy Attorney General or the Assistant Criminal Division Attorney General talk about the importance of corporate prosecution and holding wrongdoers accountable when, if they're a really rich wrongdoer who might make a donation to the president, and the president is going to order us to drop the prosecution, who the hell is going to take the Justice Department seriously after that? CEOs of US companies would just look and say, well, in that case, I'm going to put another $1 million into the inauguration fund or some other political action committee, and then our regulatory issue is going to go away. So I don't have to pay much attention to corporate compliance. I worry about that a lot with the Trump administration. He has given no indication that he won't do anything like that. It would be nice if he did give some reassurances. I probably won't believe them even if he does, but we'll see where it goes. But if there were any test case that could bring this into sharp relief,
We could probably spend 30 minutes on this one. So maybe it's time to move on to your next one, which is TD Bank and TD America Bank.
yes, I am wondering whether anybody is going to be personally charged for the TD Bank compliance scandal. That was the huge anti-money laundering settlement that TD Bank had to pay. I believe it was in October or November, $3.1 billion in penalties, a cap on future growth until they rectify their compliance program, which the remediation list is long and extensive, but nobody personally charged yet. And so that is a question I have. Will we see a senior executive at the bank or a former senior executive face some sort of personal liability for this? I am not the only one asking this question, none other than Elizabeth Warren, senator who will now be the ranking Democrat on the Senate Banking Committee. And yes, Democrats are in the minority, but still, ranking member is going to be a powerful position. And Elizabeth Warren takes no prisoners with banks. She wants to know, why has nobody been personally held accountable? That is a fair question when you look at the nature of the offenses that TD Bank foisted on people. They had that zero cost growth paradigm. I think it was called the flat cost growth paradigm, where they basically just didn't invest in compliance. They chose not to invest, which let the compliance capabilities wither as AML risks grow. Somebody had to decide that was a good idea. Who? And why are we not charging that person? If you read the indictment against TD Bank, it certainly paints a pretty damning picture that leaves open the prospect of charging individuals up to and including possibly senior compliance executives who were in on this harebrained approach to compliance management, who were going along with this zero growth and who were reaping bonuses for keeping their costs below minimum. So I don't know, maybe we would even see compliance officers personally charged here. And I'm not sure that wouldn't be unwarranted. The indictment paints a very unflattering picture of the people who were in charge there in the 2010s. So we'll see.
So, Matt, for the record, we have had some individual prosecutions in the TD Bank case, but that was for low-level employees who were involved in money laundering or
Yeah.
other illegal acts. In addition to the senior executives, I wonder, will this be the largest Caremark shareholder derivative action ever, based upon what we saw in the settlement documents? That it appeared actual knowledge went literally to the board of directors, both in the U.S. branch and Canada as well. So I'm going to be watching Caremark on this one in Delaware. We've talked a lot about Paul Atkins. What are your questions for him at this point?
Oh, I have a ton of questions I would like Paul Atkins to answer. He is Trump's nominee to be chairman of the Securities and Exchange Commission. Barring some wild twist in the plot, Atkins is going to get confirmed. I'm not exactly sure when, but presumably by April or May, he's going to be running the Securities and Exchange Commission. Fine. He is not an unreasonable candidate to run the SEC in a Republican presidency. However, Mr. Atkins was last at the SEC as a regular commissioner 20 years ago in the Bush administration. Well, my question was more, how will Paul Atkins take his 2000 era policy positions and translate them into 2020's era problems and challenges we have? It's fairly easy to get a rough sense of what he believes. We're going to see a much lighter touch on enforcement. We're going to see a much lighter use of corporate penalties. But how's that actually going to work and be justified? I'll give a quick example of corporate penalties where when Atkins was there at the SEC 20 years ago, he pointed out that corporate penalties really only penalize shareholders who were not responsible for the misconduct and were already suffering because the company had already had an issue. And that imposed losses on the shareholders. Maybe that was revenue they didn't get or profits that had to be restated. Why penalize them again? That's true in a narrow sense when you're talking about financial statement fraud, which was all the rage back then. That's why we got the Sarbanes-Oxley Act, because accounting fraud was so rampant. And CFO is corrupt, screws over the shareholders, they lose a lot of equity, and now we're going to dump penalties on them too. That's not fair. I will allow that argument. But 20 years ago, we really didn't have FCPA prosecutions. They were only starting to come into vogue when Paul Atkins left in 2008. So how's that going to work? Because shareholders don't really suffer from an FCPA scandal at a company. If the share price has any blip at all, it recovers quickly. And it's not like they're losing equity. You don't have to restate financials for an FCPA incident. Shareholders aren't suffering. Does that mean the corporate penalties are warranted there? I think they are. Maybe Atkins thinks they're not. I'd like Atkins to explain that. That would be interesting. How is he going to handle cybersecurity enforcement? Again, that was not really a thing when he was last at the SEC. The SEC did not even start thinking about cybersecurity enforcement until 2011, 3 years after he left. So if a company has a major cybersecurity failure, should that be disclosed? If it's not disclosed, should the company be sanctioned for it? Because a cybersecurity failure can cause real pain to shareholders. But then also, so do we have the disclosure, but not the penalties? Like, how's that going to work? There are a raft of issues that simply didn't exist in the way that they did when Atkins was last there, that his 2000s era approach might not really graft well onto the problems that we're looking at today. Maybe they would. Maybe he's going to come up with some grand unified theory of conservative banking securities regulation. I'd be curious to see what that is. And we're going to have to wait for it. But it's going to be a jarring experience to see what Mr. Atkins will do there. I have seen news reports that he wasn't really eager to take this job, frankly, because he thought that current chairman, soon to be departed, Gary Gensler, had done such a terrible job that Atkins didn't want the mess of unwinding what Gary Gensler had done. Look, I don't know. Maybe that's true, but regardless, there's going to be an awful lot of policies that are going to shift quite a lot. How are they going to shift? And is there going to be some explanation of the philosophy there for all of the new problems that now exist that weren't there when Atkins was there before?
How about the CFPB?
Yes. So the Consumer Financial Protection Bureau, this is the agency that regulators love to, or that, I'm sorry, that Republicans love to hate. Now, that is not an exclusive club with Republicans. They always love to hate agencies, but the CFPB seems to have a unique hold on the Republican mind. So how will this Republican administration handle the CFPB, which is one of the few agencies left where President-elect Trump has not yet nominated somebody to succeed the current chairman, Rohit Chopra, mostly because Chopra has said he's going to stay around until Trump tells him to go. And nobody actually wants this job because everybody hates it. So you're going to be the CFP director to reign over its demise and its dismantling. How is that actually going to work? I'm also curious because it's easy to say, let's streamline the CFPB, but it was created by the Dodd-Frank Act, which means to eliminate this agency, to radically restructure its oversight where it has only one director. That's going to take an act of Congress. I am skeptical that Congress will be able to do that. I am skeptical that Congress will be able to agree what day of the week it is. So, how are we going to actually enact a statute to get rid of the CFPB, if at all? The CFPB is actually also on the radar of Elon Musk and his DOJ committee, where he said that the CFPB should just be deleted outright. The Trump administration can't do that. The DOJ committee can't do that. An act of Congress can do that. I don't think Congress can get an act of Congress passed to do that, but maybe it would happen. And then the other unique thing about the CFPB is that if this Consumer Financial Protection Bureau goes away, the powers that it has would then devolve back to the states. And that is expressly stated in the Sarbanes-Oxley Act. I'm sorry, in the Dodd-Frank Act of 2010. Dodd-Frank Act created the CFPB and then said that if the CFPB suddenly ceases to exist or it doesn't enforce, the enforcement issues could then devolve to the states. That's going to be an important part of the regulatory climate that we have to think about for the next 4 years. As the Trump administration and the DOJ people want to get rid of this or that or the other thing, just because the federal rule goes away, if it goes away at all, that doesn't mean that the issue will go away entirely. It means the issue is going to go somewhere else. And maybe it's going to go to the states. State attorney generals, state banking regulators, they would be delighted to pick up this consumer financial protection mantle and start bringing their own cases. So we go from one CFPB hassling the banks to 50 attorneys general or 50 banking regulators who are going to be regulating the banks in piecemeal fashion. Like, I don't think your compliance situation has improved if you're a large bank. It's just become more complicated. And so in many ways, Tom, I think the CFPB and its fate kind of show the complexity of what deregulation is actually going to be. It's easy to say we're going to deregulate everything. It's going to be really hard to do. And even if they succeed in that, I think a lot of deregulation is going to be like pounding a puddle of water with a hammer. It's just going to splash into another puddle somewhere else. But compliance officers and businesses will still have that risk existing in a different form.
And Matt, for your final issue, it's one of your favorite new words, DOJ.
DOJ committee, yes. I'm just curious, is the DOJ committee actually really going to do anything? I think that they will do a lot of talk, mostly on social media, but I don't even know, is this commission an actual commission? Do they have committee meetings? Are these meetings even going to be public? When Elon Musk published an op-ed about what the DOJ committee is going to do, he said that he's going to have a lean team of small government crusaders, and they're going to identify rules to be repealed. We don't know who these people are. We don't know where they're coming from. Are they going to do this behind closed doors? Are they going to make it up on their own? Are they going to consult with various groups that might be affected by these DOJ committee decisions? Are we going to see these issues, these deregulatory recommendations, be hauled into court? Thanks to the recent Supreme Court rulings last year that sort of weakened regulators' ability to make regulations stick, I think we should all remember that can work in reverse too. Technically, for every rule that you want to repeal, you have to file a notice and public comment to repeal that rule. That's going to take time. Then you repeal it. Somebody might take that repealing decision to court, and maybe some judge somewhere else, now that they have new freedoms to do what they want and ignore regulators, they might say, no, we're going to do something quite different. Thank you, Loper Bright. Thank you, Corner Post decision. How is that actually going to work? There are also, I think, Tom, big geopolitical issues here. I have a hard time believing Elon Musk is really going to invest that much time and attention on what deregulation would really need to be. I am unconvinced that he and Donald Trump are going to stay BFFs forever. I don't think that there aren't enough regulations that exist to hit these cost cutting targets that they're talking about, $2 trillion. And you and I have talked about that before. You can't cut $2 trillion from the federal deficit. There's not enough discretionary spending to hit that $2 trillion target. There just isn't. There aren't enough employees to get rid of unless you start cutting into U.S. armed, uniformed military personnel. You could cut every other single person in the federal government payroll. and you're still not going to hit your targets. And even if somehow through whatever kind of weirdo alchemy, DOJ does all of that, then what about the state regulators who are going to swoop in? What about private litigation that's going to swoop in and sue companies for mishandling a risk that had been regulated? Now it's not. We could spin this up over and over, but Tom, I am just not convinced that the DOJ people are really going to be able to execute anything anywhere near what they think they can or what they're promising.
That last sentence may apply to the entire second Trump administration.
That's possible too.
Matt, I have one I want to throw out for you and came to me this morning, and it's around Boeing. The court had ordered Boeing and the Department of Justice to return by last Friday to report on a new proposal for a monitorship. And the parties jointly reported to the court they could not do so and have not done so. So that leaves us here we are in now January 2025 with Boeing with no resolution to the claims by the Department of Justice that it violated the prior deferred prosecution agreement. That agreement included a guilty plea and a monitorship, which the court has rejected. This, of course, also has victims' rights. The families of the two 737 MAX air crashes have a say in this in front of the court. But you see anything down the road which might tell us something, or is the DOJ just going to punt it to the next DOJ administration and say, you figure it out?
I think absolutely they're going to punt this into the Trump administration because that's only 2 weeks away. And there's no way this gets resolved in 2 weeks. I do think that the judge in this case has done a disservice to all parties involved by getting hung up on this DEI language, the word that cannot be spoken aloud now in Republican circles, that somehow, because the word DEI was used in monitor selection, that means that this monitor that the Justice Department wants must therefore be invalid. And that has nothing to do with bringing justice to the victims. Now, they do have a strong claim to be heard. And I don't know how much we need to tailor this settlement to their satisfaction, but they are an important voice. The judge getting hung up on the DEI thing, that is not an important detail. And it is ridiculous that we are delaying this important case because of that. However, I don't know what the solution here is for the Justice Department. Frankly, if I were the Biden people, I would be more than happy to punt this off to the Trump administration now, too. I think ultimately it won't really change much about who the monitor is just because they have a clause saying we should think about diversity in selecting a monitor. That does not mean that they went and picked some sort of a unqualified person because they were looking for a minority status. None of what the judge was saying there has any truth or any grounding in reality. But I don't know what the solution is going to be for this extra wrinkle of the victims, that they're not happy with the penalties that Boeing is paying. That is a fair question to raise. And that, I think, is the thing that matters most is penalties and personal accountability at Boeing, not who the monitor is. It is a shame that we are glommed onto the monitor issue and we're ignoring the other bigger issues that the victims are raising. I would like to see how that case gets resolved. Tom, I am not sure how much bearing it would have on the compliance community overall, because very few corporate settlements do have this extra dimension of actual victims who are a third party that deserves to be heard. Most times it's just your company and the government. So we're not ever going to have these wrinkles. And certainly this DEI issue that the judge sank his teeth into, like that's never going to come up with the Justice Department under Trump anyways. So it's a fascinating case. It's going to be an interesting thing to see how it does get resolved. I'm not sure how consequential it will be for settlements overall.
So I think the victims, their objections were equally as vehement against the monitor, both in monitor selection, but more importantly in monitor reporting, because they saw the opaqueness of the reporting directly to the Department of Justice with no court oversight as something that would not really lend itself to getting Boeing fixed, at least to their satisfaction. So I think that's one point. The second point is this is the first time we've had substantive court involvement in a monitorship. Now, we did, as you correctly noted a little bit earlier in the ZTE case, And in this case, we do have victims. But I thought this court's concerns, or at least the court's ability to interject itself, turned on the criminal plea. And if we have criminal pleas going forward, that might give courts more input or at least oversight around either monitor selection and or monitor reporting. I guess I see it in that way as something that really could impact monitorships going forward, with a caveat that you also noted it's a really minor part of settlements. But if we're going to have more criminal pleas, I could certainly see more court involvement in either the monitor selection or the monitor reporting.
I would just say, number one, I don't think we're going to see more criminal pleas in the Trump administration. But even if we do, in a case that does not involve victims who are the vehicle to raise these valid questions, how is a judge going to get to the questions? I suppose that is my question. If it's just the two parties who agree to this, and the judge is going to weigh in and say, no, I don't like how this monitorship is going to be structured. I want the monitor to report to me. Tom, I don't know, but like, how often has that actually happened? Because I can recall cases related to the global financial crisis in the early 2010s, where I think it was Judge Rakoff up in the Second Circuit in New York. He had said that he wanted more input into who a compliance monitor was, and these reports, and could they become public? And that went up to the appellate division in the Supreme Court, and they're like, the appellate division of that circuit. And the appellate circuit said, no, judges have no role in this except to rubber stamp what the Justice Department and the company agree to. Now, this is a different case because there are three elements here instead of two. But if there's only the two, assuming we even get to a criminal settlement as opposed to just a declination, which I think is mostly what we're going to see in the Trump world. But I don't know how a judge could then decide to take it upon himself. Nope, I don't like this monitorship. I'm going to rewrite the terms so I'm the star of the show. I would guess the company and the Justice Department could probably appeal that. I don't know how far that would go. It seems, yeah, I don't know how that can of worms is supposed to get open.
Specifically with Judge Rakoff, he was concerned that the settlement was literally insufficient based upon his reading of the damages that were caused. So I don't think it was a judge trying to interject himself to be the star of the show, but more he didn't think that the overall settlement agreed to by the parties met his definition of what should have occurred. So at least with Judge Rakoff, we saw him do it, as we would say in law school, sua sponte, on the
But
court's
he
own motion.
lost. He got
He did
slapped.
lose.
Yes.
He did, and he got slapped hard, and that's why I thought maybe this case might change that jurisprudence.
I don't know.
Matt, it was a ton of fun visiting with you on these issues. I can't wait to see where they go, and I look forward to what we come up with next week.
Thank you, Tom.